Welcome to this edition of Diligent Institute's Inside Today's Boardrooms. I'm TK Kerstetter, and I'll be your host for today's show. Today, we're going to be talking about the growing importance of corporate board minutes. And joining me to have this discussion is Amy Simmerman, who's a partner with Wilson, Sonsini, Goodrich, and Rosati. Welcome, Amy.
Thank you for having me.
Well, it's a pleasure to have you back. So, as you know, this is a topic that I occasionally get on my soapbox for, just because it's so important. And certainly we've seen incidences recently. When I think back on the past, I think of how important it was that Target, had documented their cyber discussions. And, certainly I'm sure Boeing wishes that they would have documented better their safety discussions. But anyway, it is proving time and time again to be a very important process that I think sometimes directors sort of take too lightly. So I thought this would be a great chance for us to sort of refresh everyone on the importance. So let's start with a sort of the general, why do minutes matter?
Sure. And so just to set the stage a little more on that, what we want to keep in mind here is that directors are likely to face stockholder litigation at some point. That's true of public companies particularly, but it can be true of private companies as well. And on top of stockholder litigation, what we've seen more and more in recent years is stockholders are exercising their right to bring what's called books and records demands. And that's a right stockholders have under the Delaware statute. And as part of those demands, they frequently receive board minutes. That's some of the first evidence they get. And so what we see in these situations, whether it's stockholder litigation or responding to books and records demands from stockholders, minutes really are the first evidence that is put out there. They're go-to evidence for judges and for plaintiffs' attorneys. The judges have said again and again in Delaware how important minutes are. And so we want to be cognizant of this when minutes are being prepared and reviewed. And what we also want to keep in mind is that we've really seen minutes come up and get a lot of focus in particular contexts that directors will want to keep in mind. So TK, as you alluded to, minutes have come up a lot in oversight claims against boards of directors, where take the Boeing case or the Bluebell case, there's an argument that directors were not exercising proper oversight over the company, that there wasn't a proper system in place for ensuring that the company was complying with legal obligations. We've seen minutes get examined a lot in those situations to see what was the board doing? Was it taking adequate action? But it's not just there. We see minutes get scrutinized in stockholder activism situations when there are claims that boards had conflicts of interest and acted inappropriately. Minutes get closely examined to see if boards understood what the conflict was, if they handled it appropriately. Minutes also come up a lot in the M&A context if the company decides to sell itself, and that's obviously a critical watershed moment for companies. And so bringing that all together, we want to keep in mind a couple things. Minutes are critical evidence. Given all of that, you can use minutes defensively, right? When minutes are looked at, we want to make sure that directors have had a chance to tell their story in a thoughtful, well-done way. But there is also this proactive element to minutes, right? Where it's a forum for directors to tell their story and show what they did and why they did it. And keep in mind, something we've seen in these situations, especially the oversight claims, is if something's not in minutes, it's hard down the road to explain to a judge or a plaintiff's attorney that you actually did it. If it's not in the minutes, there will be a presumption that you didn't do it as a board.
So we don't, by having this video, we don't want to push things too far. I mean, in the sense of that's, documenting every little thing that happens. Okay. So what's important to see in the minutes, at the end of the day?
Yeah, and you're right. There's an art to it, and this falls largely on counsel, of course, where you need to strike that balance and have an appropriate level of detail. And so, keep in mind, we all regularly see minutes that are fairly spare, fairly Spartan. And I don't want to get too carried away with what I'm about to say, but sometimes that may be okay if the board is doing something pretty ministerial, pretty straightforward, pretty basic, right? We're not indicating that you need 2 pages of minutes for something very basic or ministerial that a board does. But when you are doing more important things, more delicate things as a board, that's where we want to see a certain appropriate level of detail. But to your point, TK, it's not to say that you want a transcript-like detail of back and forth between directors, and you don't necessarily want too much detail. There's an art to it. The way I do it and what I tell clients is that you want to be able to show what the directors considered, the topics they thought about, why they did what they did, who they got advice from. And it's not as though you want the blow by blow on that, but at a high level, those are the types of things that you want to be able to see.
So it's certainly interesting when we see things like FCPA, and that there's some confirmation that the board's aware of this. There's a lot of compliance things, as some standards, some sort of critically important to make sure there's at least reference in there. Cyber's another where you want people to have some record that they discussed these issues, like you said previously, to prove that the board was aware that this was an important process for them to go through. But what else might be important for boards to understand about the record that they're building with respect around this process of going through the minutes?
Yeah. So we've talked about the appropriate level of detail that you need. And then there are a few other things you want to keep in mind. First, related to minutes, you want to make sure, and directors need to do this hand in hand with their counsel, you want to make sure that minutes are reviewed and prepared and approved by the board relatively promptly. And that can mean, by the way, different things in different situations. If you're talking about quarterly board meetings, then you can be on a cadence of approving those in a timely way. If you're talking about special board meetings where you're looking at particular transactions or particular decisions, there are probably appropriate milestones in the process where you're approving minutes and getting that all taken care of. What you want to avoid is having minutes done wildly after the fact, where judges may have skepticism as to whether minutes were accurate and done in the proper way. And then you want to make sure that minutes are tying up loose ends from one meeting to the next. This is really important, like you said, TK, in the cyber context, the oversight context. If an issue is brought to the board and it could be a potential problem for the company, you want to make sure that in the next meeting, you're taking care of that issue or following through on that issue. Another thing I like to show is that directors are getting materials and that they received them in advance of the meeting. That's an easy passing reference you can put in the minutes, but it puts an important stake down as to directors getting materials and doing their homework. Another thing to keep in mind with minutes, and then we should probably move on to other aspects of the record. Another thing to keep in mind with minutes is that you don't want to do too much blow by blow of the legal advice where you have, Ms. Simmerman advised us on all of these different factors and you have 2 paragraphs of details about what I said about legalities. That's not good, because in the chance that legal privilege is waived, it gives plaintiffs a whole lot of information about legal advice that you don't want in there. But also keep in mind, if you're in the Delaware courts, what you end up doing is redacting all of that legal advice because you don't want to waive privilege, and you have a judge looking at a page of blacked out material. So you don't need a ton of legal advice in your minutes. So that's all what I would say about minutes in terms of what else you need to be thinking of. But you also want to think about the remainder of the written record as board members. And what we mean by that is keep in mind that minutes are really critical. But we're also seeing in stockholder litigation that texts are obtained and produced, emails are obtained and produced, other electronic communications are obtained and produced. And so what can happen is you have good, thoughtful minutes that are well done, but then you have casual electronic communications that people aren't thinking carefully enough about that undermine the director's story. So a couple things there. Keep in mind those things can be obtained depending on the nature of the stockholder litigation. So don't get too casual with your electronic communications, including texts. Keep in mind someone could look at them one day. Also keep in mind it might be better at times to pick up the phone rather than have the casual communication or the heated communication. Maybe save that for conversation. And then the final thing I would note is keep in mind that just because a lawyer is copied on an email or a text chain does not mean it will be privileged and protected. The attorney-client privilege protects communications where there's an expectation of confidentiality and there's the giving and receiving of legal advice. Sometimes a lawyer's on things and they're really not about legal advice. They're about facts that transpired or business issues. And so you want to keep in mind, you will not necessarily be protected just because a lawyer is on your communication.
So just one last thing. I know that there's always advice on taking notes. And I remember back when I was serving on the board, this is obviously the dark ages where we took notes on the side of pages and stuff like that. Today, all the board books and stuff is electronic. And I know in Diligent's case, a corporate secretary or the GC can go through and review notes that we're taking and either eliminate them or whatever, obviously as a part of their process, not once litigation is there. But I know that it's important for people to know what they're writing down, just to your point.
That's exactly right. If you're still, as a director, taking paper notes sitting at your desk, those could potentially be obtained in a stockholder litigation. So keep that in mind, right? If you write some marginalia down that's really derogatory about someone, that could be produced one day. And I realize directors need to take notes sometimes to keep themselves on track, but just be mindful of what you're writing down. And you might want to have a conversation with your counsel, either at the company or outside counsel, to talk about what that looks like and how you might want to approach it. And, to your point, TK, keep in mind other ways of recording things. We've seen some horror situations where people actually have recorded board meetings because they think for some reason it might be a good idea, and that's obtained down the road. You probably don't want to do that. And then we're also, of course, to your point, TK, seeing a much greater use of board portals now. And that's a good conversation to have with company counsel, outside counsel, about how much material is in those, how much is being stored in the portals, how much of a repository are we creating for future discovery and litigation? It's definitely something to think about.
Well, Amy, this has been a great session as far as a refresher for anybody that hasn't thought about this in a while. And I think you did a great job on explaining the important points that all directors should know. So I want to certainly thank you for taking the time and joining us.
Appreciate it. Anytime.
And that will conclude this episode of Diligent Institute's Inside Today's Boardrooms. We hope you enjoyed the show. We'll be back again next week when we take another look at a critical topic that'll help you be a better board member or committee member. So we'll see you then.